a continuation of the first. We're in the first part of Rule 126, Search and Seizure. Talk about the requisites and particularly the one specific offense wherein a judge will only issue a search warrant specifying only with one specific. Otherwise, it will be already a scattershot warrant, in which the example is that in Papal versus Pastrina, in which the search warrant was issued for violation of Securities Regulation Code and for Estafa. So the Supreme Court ruled that it is a scattershot warrant because such search warrant has the offense pointing to violation of Securities Code, Securities Regulation Code, and also for Estafa under Revised Penal Code. So therefore, it is a scattershot. This time, we will continue about the section 4, wherein a search warrant shall not issue except a probable cause in connection with one specific offense to be determined personally by the judge. So this phrase, to be determined personally by the judge, it is the existence of facts and circumstances which would lead to a reasonable, discreet, and prudent man to believe that the offense has been committed and that the objects sought in connection with the offense are in the place to be searched. That is in Century Chinese Medicine Corporation versus People. So such facts and circumstances to be determined is what we know as the probable cause. Probable cause for the issuance of search warrant. Then, who will issue? It's the judge. It's the judge who will issue the search warrant under Section 4 of Rule 126. Probable cause in issuing for search warrant is different from the probable cause for filing of information. There is difference in probable cause for filing of information may be based on hearsay. That is in Estrada versus Ombudsman. Again, probable cause may be based on hearsay for the filing of information, but for issuance of search warrant, the probable cause cannot be based on hearsay. It must be based on personal knowledge of the complainant and the witnesses. Again, the probable cause for issuance of search warrant must be based on personal knowledge and of the complainant and the witnesses. So this personal knowledge must contain facts and circumstances that will lead to a reasonable discreet, that a prudent man to believe that the offense has been committed. And take note that the determination of the judge of the probable cause must be based on personal knowledge of the one who applies for search warrant and its witnesses. Again, the determination of probable cause must be based on the personal knowledge of the one who apply for the search warrant and its witnesses. Question: how shall the examination of the judge be conducted? Again, how shall the examination of the judge be conducted? This is now our section 5 of Rule 126. The judge must, before issuing the warrant, personally examine in the form of searching questions and answers in writing and under oath the complainant and the witnesses he may produce on facts personally known to them and attach to the record their sworn statements together with the affidavit submitted. So, how? By simply giving questions and answers. Q&A. It's a Q&A. And it will be in writing, under oath by the complainant and the witnesses. Together with them, their sworn statements and affidavits. So again, if you will be asking how is the examination of the judge be conducted, it is personally examined by the judge from the personal knowledge of the complainant and the witnesses that he may produce, and they will be under oath. It will be under oath. Next question. How shall the examination by the judge should be conducted? How? Although there is no hard and fast rule governing how a judge should conduct his investigation, it is nevertheless required that the examination must be probing and exhaustive. Again, there is no hard or no fast rule governing how a judge should conduct his investigation. It is nevertheless required that the examination must be probing. Probing must probe and exhaustive. Exhaustive means getting all the remedies, getting all the manners, means and methods to extract circumstances, facts that is related to the commission of the crime. Not merely routinary, general, peripheral, perfunctory, or pro forma. The judge must not simply rehash the contents of the affidavit, but must make his own inquiry on the intent and justification of the application. That is in Yao, Senior versus People. Again, there is no hard or fast rule governing how a judge will conduct the investigation. Nevertheless, it must be probing and exhaustive. Not just routinary, peripheral, perfunctory, pro forma, not just only scanning the content of the affidavit, but the judge shall make his own inquiry about the intent and justification of the application for the warrant. That is for determined personally by the judge. Now, particularity of place and things. So, as a general rule, the place and things to be searched and seized must be described in the search warrant. As a rule, again, place to be searched must be stated in particularity, means specific. However, even if the place to be searched is not particularly described in the search warrant, but the implementing officer has personal knowledge as to the place to be searched, because he is the one who applied for the issuance of search warrant, then there is no violation of particularity of place. That is in Yao, Senior versus People. Thus, if the searching officers are familiar with the place to be searched, then the requirement of particularity is complied with. So, as a general rule, the place must be described in the search warrant. But even though the place is not particularity, this particularity or particularly described in the search warrant, but the implementing officer, the searching officers are familiar with the place, then the constitutional requirement or the requirement of particularity is complied with. Any designation or description that points out to the place to the exclusion of others and on inquiry leads the officers unerringly to it satisfies the constitutional requirement of particularity. example, the sketch map in the warrant. So sketch map is attached in the warrant, so it means to say the even though it is not particularly described in the search warrant, but there is sketch map on the place to be searched, then it is already enough to comply with the requirement. How about for the things? As a rule, warrant is valid when it enables the police officers to readily identify the properties to be seized and leaves them no discretion regarding the articles to be seized. It means to say it is very clear. It makes things clear for the officer that a certain object must be searched. There is no need for them to think or to be in doubt of what article to be seized, or they will be on the spot thinking if this is the correct object, is this the object described in the search warrant. So as much as possible, officers will not anymore be using their discretion regarding the seizure of an article or of a thing. It should, in the search warrant, solely in the search warrant, the things must be particularly described. In Vallejo versus CA, the court clarified that technical precision of description is not required. Technical precision of description is not required. It is only necessary that there be reasonable particularity and certainty as to the identity of the property to be searched for and seized. Not that the warrant shall not be a mere roving commission. So again, the technical precision of description of an article or a thing to be searched is not anymore required, as long as there is the particularity and certainty, and it will not allow anymore the officers to use their discretion as to whether it is already the article or not to be seized. Now, take note that these are circumstances in which there is invalid warrant. First, if the search warrant states only book of accounts, financial records, etc., and other documents and papers showing all business transaction, again, book of accounts, financial records, and other documents and papers showing all business transaction. If this phrase is stated in the search warrant, it is an invalid warrant because it seems that almost everything has to be taken. They did not make any particularity. That is in Stonehill versus Jokno. So again, the general rule is that, or as a rule, the thing to be searched, the articles to be searched must be with particularity and certainty of description in the search warrant. Do not take everything like these other documents and papers showing all business transactions. It should be specific only what kind of business transaction. Next, television sets, video cassette recorders, rewinders, etc., and other machines used or intended to be used in unlawful reproduction, sale, rental, lease, distribution of above mentioned videotapes, then it is again an invalid warrant. That is under 20th Century Fox Film Corporation versus CA. Television sets, video cassette. It is already clear that television set, video cassette recorders, but it should be with particularity or certainty. It could be brand of the television, brand of the video cassette, or the name of those machines that is intended to be used in unlawful reproduction. So it should be with particularity and with certainty, because if these will be allowed in the search warrant, officers will be using their discretion as to whether these machines to be used in unlawful reproduction or not, whether these objects will be used for unlawful reproduction. So in this situation, officers will be using their discretion as to what object, as to what extent those machines described in the search warrant that will be used for unlawful reproduction. So it is invalid if these phrases are in the, or if this kind of phrases are stated in the search warrant. Next, multiple sets of books, ledgers, journals, etc. Multiple sets of books, it's vague, not clear. Books, what kind of books? Ledgers, journals, invalid. UI versus BIR. For valid warrants, like this is example, unlicensed firearms of various calibers and ammunitions for said firearms. That is Inco versus Makalintal. Unlicensed firearms of various calibers and ammunitions for said firearms. So it is very clear that unlicensed firearms, they are not licensed, they are not registered. Next, undetermined amount of marijuana or Indian hemp. So marijuana, regardless of the amount, the weight, still it's a marijuana. It's very clear that the thing to be seized here is marijuana. The thing to be seized here, firearms, ammunitions. That is in People versus T. Search warrant, the implementation. As a summary, when? In section 9, before going to section 9, section 6, issuance and form of search warrant. If the judge is satisfied of the existence of facts, or if he finds probable cause upon which the application is based, or that there is probable cause to believe that they exist, he shall issue the warrant. The right to break door or window to effect search. The officer, if refused admittance to the place of directed search after giving notice of his purpose and authority, may break open any outer or inner door or window of a house or any part of a house, anything therein, to execute the warrant or liberate himself or any person lawfully aiding him when unlawfully detained therein. So the right of the officer to break door or window, on what ground? If there is refusal to admittance the place or directed to search after giving notice. So upon the officer giving his authority or purpose, he was refused by the owner of the house to be searched, then such officer may break any outer or inner door. Or if he is already inside, the officers are already inside, they are, or there is a person that is unlawfully detained therein, seeking for help, officers may break in and liberate those people who are unlawfully detained therein. Let's go to section 9, wherein time of making search. So search warrant implementation. When? Under Section 9, the warrant must direct that it must be served in the daytime. It must be served in the daytime unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which case a direction may be inserted that it be served at any time or day or night. So, as a general rule, the warrant must direct that it must be served only in daytime. Daytime, as a general rule, daytime. Unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which case a direction may be inserted. So there will be a direction already that it may serve at any time of the day or night. So the person needs to be searched because the property is on him, in his possession, or it's in the place. So therefore there must be a direction that it must be served at any time of the day or night. Again, how? We will go to section 8. How? Section 8, search of house, room, or premise to be made in presence of two witnesses. How is search warrant is being implemented? No search warrant, no search of a house, room, or any other premise shall be made. No, that's a constitutional right. No search of a house, room, or any other premise shall be made except in the presence of the lawful occupant thereof or any member of his family, or in the absence of the latter, in the absence of the family member, two witnesses of sufficient age and discretion residing in the same locality. Again, it is a rule, no search of house, room, or any other premise shall be made except with a search warrant, together with the presence of the lawful occupant, the owner of the house, the one who is occupying the house, or any member of his family. What if there is no lawful occupant? There is no family residing in the house, in the room, in the premise. At least two witnesses of sufficient age. So the law is very clear that it may be legal age, sufficient age, to witness the searching, and discretion residing in the same locality. It can be a neighbor, or it can be a person who is residing in the same locality, in the same barangay, or it can be the barangay tanod, barangay chairman, barangay kagawad, residing in the locality. Next, section 7. It's the right to break again, diba? It's the right to break a house. Next, section 11, wherein the officer seizing the property under the warrant must give a detailed receipt for the same to the lawful occupant of the premises in whose presence the search and seizure were made, or in the absence of such occupant, must, in the presence of at least two witnesses of sufficient age and discretion residing in the same locality, leave a receipt in the place in which he found the seized property. So it is about giving a copy, or notifying the occupant, notifying them, by giving them a detailed receipt. What's that, a detailed receipt? It's a written a copy of the search warrant, leaving them a copy, or in the absence of the occupant or the family, at least two witnesses of sufficient age, the barangay kagawad, or residing in the same locality.